Good afternoon. It's about 3 minutes after 12. My name is David Cohen. I serve as Executive Vice President and shareholder of AKAM. For those who are not familiar with AKAM, we are a full-service real estate management firm throughout South Florida. We have the privilege of servicing more than 20,000 units and have over 700 employees, with our main offices in the Design Center of the Americas off of Griffin Road and I-95. If your property ever requires management services, if you are a board member, please do not ever hesitate in contacting us to serve as a resource. If you are a property manager or general manager joining us today and are looking for opportunities for advancement or growth, AKAM is constantly soliciting and recruiting industry professionals, and we look forward to having the opportunity to meet you. Thank you again for joining us today. Our session today is an industry favorite as of right now with COVID, which is annual meetings in the age of COVID-19. I'm joined today by Avi Tryson, who is a managing partner at GADC. He's based in the firm's Coral Gables office, and he's been practicing community association law for almost 15 years. For your reference, his practice includes general representation, interpreting and drafting amendments to governing documents, covenant enforcement, review of vendor contracts, and facilitating board member meetings and annual meetings and so forth. And he's a great resource. He has the opportunity to work with our firm at a lot of mutual clients, and his firm has been a pleasure to work with. I'll turn it over to Avi to give a little bit more introduction on his firm, and then we will jump right into the webinar.
Sure. Thank you, David. As David mentioned, my name is Avi Tryson. My law firm is Goede Adamczyk DeBoest Cross, which is a mouthful and not something you'll be tested on. My firm's been around for a little over 12 years, 13 years now, but the partners have been working for far longer than that in this area of law and specializing in this area of law. We have offices in Miami, Boca, Fort Myers, and Naples, as well as in Pensacola. And we serve community associations all throughout the state of Florida, whether it's collection work or litigation, of course, general representation, as David mentioned, with regard to covenant enforcement and negotiating contracts on behalf of the association. Teaching courses like this is something that we love to do. We like to give back to board members and other community association managers who are just looking to get some information on what's going on and how to handle this crisis. I do need to note, as most lawyers do, that this presentation is a general overview of what's going on. It is not a substitution for direct legal counsel, which the association should get from its lawyer. We are happy to be that lawyer if you would like to contact us after this. And this presentation does not create an attorney-client privilege between us. And that's the legal stuff that I need to get out of the way before we go forward. But we're here to answer questions if you have them throughout the presentation, as well as some discussion topics that we will go over throughout the course of the next 45 minutes or so.
Fantastic. Avi, once again, thank you so much for joining us today. As I mentioned earlier, the topic for our webinar this afternoon is annual meetings in the age of COVID-19. We're going to be going through more of a Q&A forum this afternoon. The webinar should last about 30 minutes. It's also being recorded, so for any general managers, board members out there that want to share it with your fellow colleagues or go back for any industry information, you're welcome to do so. I also want to take an opportunity to reiterate that AKAM has been providing management services for more than 37 years. And we certainly welcome the opportunity to serve as a resource to you in any capacity. And then last but certainly not least, if you have any specific questions relating to the topics today that we discuss, there is a Q&A button at the bottom of your Zoom screen. We welcome you to participate and ask your questions. We will certainly attempt to get to all of them. As you can imagine, we have quite a number of attendees that have joined us for the webinar today. But again, we will do our best to get to every single question. And if for any reason we do not, you're welcome to contact myself or Avi directly via phone or email following the webinar. So to start off, Avi, what should our governing documents say about emergency powers and any recommendations on what you have learned?
So one of the biggest things is what's the liability for board members, obviously. And some documents just mirror what the statutory emergency powers are, or they broadly state that the board has emergency powers, which is good. But there is a general lack of insurance, which we'll talk about in a little bit. And so the best we can try and do is cut the legs out of an argument that the board is negligent for a breach of any particular duty. So the language that you see on the screen is the language that we're requiring our clients, recommending, wouldn't say requiring, but we suggest it strongly to them to add if it is not already in their governing documents or something similar, that it's just really going to, and I'm going to read it, that corporate action taken in good faith to further the ordinary affairs of the association where there's an emergency shall bind the association and shall have the rebuttal presumption of being reasonable and necessary. And any officer or director, which protects a lot of you guys that are watching this, or employee of the association acting with a reasonable belief that their actions are lawful in accordance with these emergency bylaws shall incur no liability for doing so unless it's in the case of willful misconduct, which means you're purposefully doing something wrong, which is not the intent with someone that's trying to, and we'll get into preventing certain people from coming onto the property or enacting certain requirements when it comes to the use of amenities that we'll also discuss. So the concept is to bolster your documents as much as you possibly can. And you can't ever avoid a lawsuit. People are going to sue in Florida, where it's a very litigious state. People sue anybody for anything at any time, and here too often, of course. But this is something that the board can use to protect itself from being individually liable, and also the association to be potentially liable as a whole.
Thank you, Avi. We have an interesting question that just came in, and it goes towards the annual meeting side of this discussion. Brenda's asking, if an association is holding a membership meeting via Zoom, does an owner's attendance count towards the quorum?
So no, unless that association is using electronic voting, which was something we were going to talk about later, but I can talk about it now. In a condominium, individuals cannot vote through a proxy for a director for an election. They can use proxies to vote for waiving reserves or amending the documents or on a material alteration or anything else, but they can't vote for a director that way. So in order for an owner to vote, they need to vote by using the double secret method on the condo side, and to be present, they would need to mail in a general proxy saying this is the proxy for me being there. So it's kind of a two-step process on the condo side. On the HOA side, you can vote for directors through a proxy. And so an owner could mail in their general proxy and their limited proxy of who they wanted to vote for. And then they would count towards quorum, even though they're not there, because that proxy would be counted towards quorum. But showing up in that capacity over Zoom does not necessarily work. And I'm kind of couching this in the caveat, if you have a 12-unit condominium, you can have a telephonic hearing or meeting, and I've done that through COVID. But when you have a 300-unit building, it's just not practical to have that sort of setup.
Brenda, I hope that answers your question. And again, thank you for the question. When we talk about signage, Avi, a lot of associations, particularly over the last year, with opening and closing amenities, has discussed what type of signage should be placed throughout those amenity areas. What language do you recommend for signage if associations do open up a specific amenity?
Sure. The language that's here, and I can go over in a second, but some of it was actually we borrowed from Disney, because Disney used some of this language to reopen their parks and to post around their parks. And just based on the fact that Disney is Disney, we assume their lawyers did a very thorough job of it. And we added some things to make it applicable to community associations. to try and enhance it a little bit. But the idea is basically to tell an individual that while the association is taking their reasonable precautions to keep the area COVID-free, the association cannot guarantee and isn't guaranteeing that the area is COVID-free, and whoever's using that amenity or area or whatever it is doing it understanding the risk despite these precautions. We recommend that the signage list CDC recommendations such as frequently washing your hands, using hand sanitizer. I was going to say bacteria, which of course doesn't make any sense. Using hand sanitizer, wearing a mask, and socially distancing. And the association needs to take the steps to comply with the CDC guidelines to the best of its ability. So if the association is going to open up the pool, for example, and they're going to space out the chairs that are on the pool 6 feet, so they're socially distanced, and they're going to put up hand sanitizer stations, and they make an announcement to everybody, here's our protocol, we're going to check these every 3 hours, we're going to shut the pool down for an hour, we're going to give it a thorough cleaning, and the pool is only going to be open during these particular hours, and then the association doesn't follow its own protocol, then the association is opening itself up to liability because they're not following through with that duty that they created for themselves. And so I don't necessarily need to read this. We'll leave this up for a little bit so you guys can read it, but it just goes along the concepts of what I just spoke about.
Thank you, Avi. The next question that I have is something that comes up quite a bit more recently with associations that are conducting board meetings via Zoom. In a condo association, can the board meet via Zoom video, but only allow owners to attend via audio and not video?
No, and one thing I want to mention about signage, sorry, before we go on to this, at a minimum, these signs need to be at all entrances, all exits, and anywhere where the amenity has been open, whether it's a gym or the pool or what have you. We do recommend emailing owners the signage and the protocol that the association is going through, but emails by themselves will be an issue for the association to potentially create liability. Number one, a lot of people read emails and kind of put them aside or don't even read them and never pay attention to them. And you may also not have the email address or correct email address for each owner or resident in the building. So you also want to put it where people will congregate, such as a mailroom, because you want to make sure that people are doing their best to socially distance and take precautions in those areas as well. As far as the question of board meeting via Zoom video and not allowing owners to participate, that is not, on the condo side, you can't do that because the statute specifically says that at board meetings, members have the right to observe what is going on. And so observe, they obviously need to be able to see it, and therefore you have to have it open to everyone. On the HOA side, for whatever reason, it's that word observe is not in the HOA Act in Chapter 720. And because of that, it's not required on the HOA side, but we do recommend it to our HOA clients just because it opens transparency, and there's no reason why you shouldn't allow people to see each other. And
in a Zoom meeting, does the board have to allow owners to speak during the meetings or on Zoom?
The short answer is yes. There's no difference between a Zoom meeting and an in-person meeting. But the joke that's been, I don't know if it's a joke, but it's fun for board members, they love using the mute button. It just makes it easier to control a meeting. For anyone that's been to an out-of-control board meeting in person, it would be nice if you could just mute everyone who is yelling and allow people to speak in an orderly period of time. On the condominium side, well, actually on both sides, the boards can pass resolutions on how the meetings will be conducted. So on the condo side, you can limit people's speech to, owner speeches to 3 minutes for each agenda item. And you can also make it where they need to sign up before the meeting starts to speak on whichever agenda item they want to speak on. And so if they don't sign up before the meeting, then they don't have the right to speak. You can also pass one of the line items being that an owner cannot yield their time to another owner. So you can avoid 6 people yielding their time to a 7th person. And so that 7th person would have 21 minutes in total if they had 3 minutes cap. And that would avoid somebody just speaking forever and tying up a meeting. On the HOA side, the only difference in what I just said is that the 3-minute cap for each individual owner speaking is already in the statute. I don't know why it's not in 718, which governs condominiums, but it's not. So that's the one extra step you would need to make on the condominium side.
Here's an interesting question. Can a board provide less than 48 hours notice during emergency powers for non-COVID issues, or is short notice only allowed for COVID issues?
It's generally the same rule for both. So for non-COVID issues, think fire, flood, or blood. For anything that's happening, you're on a 30-story high-rise and the unit on the 29th floor is gushing water everywhere. You don't need to have a board meeting in order to get a plumber out there to shut off the valve and figure out what's going on. You just need to fix the problem. Or if the roof gets ripped off in a hurricane, you kind of need to figure out things as you go, how you're going to secure the building immediately after the storm. If you have a situation where you want to paint the building and Frank is the swing vote on the 5-member board and he's going out of town on Friday on a cruise, you can't have the board meeting noticed for Thursday just because he's going out of town. That's not an emergency. That's just something that's happening. But if there is a true emergency, again, fire, flood, or blood, for non-COVID issues. And for COVID issues, it's generally the same thing. Anything that's reasonably necessary to protect the health, safety, and welfare of the community and mitigate further damage, as well as make emergency repairs, is where COVID kicks in. Clearly in February, March, April, that time period where things were evolving of last year, we were constantly fielding calls, and emails and questions from our board members and the property managers. How do we do this? Do we reopen? How do we reopen? And as the months went forward and the governor slowly eased, the phase 1 opening, the phase 2 reopening, the phase 3, each individual association, well, we don't really want to have this amenity open, a full 24-hour gym the way we used to because of the issues. So now there's that time to look back where things are not necessarily, at least for most of our clients, an emergency and something that has to happen now. So in that case, we do recommend giving the 48-hour notice so you don't have an issue with some disgruntled owner at a later date.
Going back to the members and owners speaking at a membership meeting, in an HOA, in a homeowners association, how long and how do you control members speaking?
Owners only have 3 minutes to speak on each agenda item, and you can control them in Zoom by pushing mute. In an in-person meeting, which we most likely won't have for a while, you really just have to try and control the crowds. I've had certain associations that have off-duty police officers there because things have gotten a little contentious, and that usually helps quiet the crowd and keeps people under control. But in Zoom, it's really easy. And I was kind of joking, but not really joking before, that board members have fallen in love with Zoom meetings because they really can control what's going on. And it's, for the most part, it's not nefarious. It's not in negative intent and with malintent. It's just with a way they want the meeting to be organized. They want the owners to have their opportunity to be heard, and then they want to move on to the next owner and get through the agenda that's there for the board meeting.
We have an interesting question that just came in from one of our attendees. His question is, or her question, I apologize. If the HOA governing documents require voting by secret ballot and nominations from the floor, is it possible to conduct the meeting via Zoom? If not, would you suggest the meeting be postponed pursuant to Florida Statute 720 emergency powers?
So it's a funny question because I've faced this a lot. In an HOA, the statute says that you are allowed to do advanced nominations, and if you have that in your documents, then you can require all nominations to be in advance and not have floor nominations. But where you have floor nominations, it makes it tricky, if not impossible, to hold an annual meeting, because anybody who wants to raise their hand and nominate themselves from the floor of that meeting won't get any votes unless their proxy is sitting at the area where the board meeting is physically being held, because there has to be a place for that meeting being held, but you can limit who is able to actually physically be in attendance because of the emergency powers. And so in these situations where the documents do not allow for advanced nominations, and so they are allowed from the floor, I've recommended clients to do one of three things: either postpone the meeting and pass electronic voting, if they haven't already, through a proper board resolution, and try and get as many owners as they can signed up so that they can have enough people that they know that they would be able to hold the election through electronic voting, and have the necessary number of people they need to hit quorum, and then they can hold their meeting and have the election. Or they can cancel it and it'll just be rescheduled for the next calendar year if they don't think that that's achievable, or they try and achieve it and it just months go by and they just aren't able to get enough people in the community to participate and sign up for electronic voting, or they don't feel that they'll be able to get enough proxies from people to vote in that manner. It's a tricky situation. The other option that I've given an HOA, and I told them I would have to write them a CYA letter, is if they want, try and run your election like a condominium. You're not allowed to do it that way, but we're in a weird state of mind. We're in a weird state of world. And if you want to try it and we can see what happens, we can see what happens. An owner can always challenge it. So you might have to deal with legal fees and dealing with an owner and vacating, what happens at that meeting. But if that's something that you want to try for your community, then we can try it. Just understand that on the back end, an owner can challenge it and they would win because you would have no authority to operate your election like a condominium does.
Excellent. A question that we've seen come up from potential clients, especially clients that are not managed by professional management or third-party management that may be looking to explore AKAM as an alternative option, is they've asked if they are required to hold an annual meeting during COVID. Is there any options for an association to either postpone or hold off for a year? Have you experienced anything like that?
Yeah, there is a requirement in the statute, and there will be, or should be at least, if there's not a requirement in their documents, the governing documents, there should be, but there is one in the statute to hold an annual meeting at least once per year, once per calendar year. But we've spoken with the DBPR on a couple different occasions, and ironically enough, on 2 of those occasions, they told us that they would not sanction, and the DBPR governs condominiums for this, so you guys know, not necessarily HOAs, but they would not sanction a Zoom election, which we found weird, but they don't approve of it, so at least they told us that. But we've run them that way, and if someone has a problem within the community, they can always challenge it, and we'll see what happens if this is brought up to the DBPR, although we haven't heard of any cases that have been decided by the arbitrators with the DBPR on this particular issue. So it is possible to postpone it. It's possible to cancel it. It's a very topsy-turvy world, and it's been that way for almost a year, almost a full year now. So communities just have to do the best they can. You do have certain communities where owners will be up in arms because, a decent portion of the residents do not like the current board and want them out. And really they would be left with trying to do a recall at that point of the current board if the board cancels the election.
We have an interesting question from James. I'm going to go ahead and read it to you. James is saying that he has his annual meeting coming up and it's going to be held via Zoom. The counsel for the association will be there at the condo property, assisting the association. Do they still need to have the board appoint owners for the counting of the ballots, counting of the votes? They will not have any attendees in the actual clubhouse for the election, other than the present board, staff, and council.
We recommend our standard operating procedure is to have us there, whether it's virtually or in the room, the property manager, at least 1 or 2 members of the board, depending if it's a 3, 5, or 7 or larger board, and having at least 2, if not 3, depending on the size of the community, independent ballot counters. And you need them under the statute in order to have a valid election. You put 2 attorneys in a room, you'll come out with 4 or 5 opinions. So, I can see the argument of it's an emergency situation. We're going to do this the best we can. We're on Zoom. We're doing it live. So everybody can see what's going on, which is really one of the key things is it's recorded. So people don't want there to be shenanigans when it comes to the election of somebody trying to throw in some votes that weren't really there, or ballots. And so it's obviously I'm assuming it's recorded, and it's on Zoom. So anyone who wants to attend the meeting or view it later will be able to see what happened with the process of opening the ballot, opening the envelopes, and then getting to the ballot, and then the counting of the ballots. But we would recommend having owners who are not related to or not board members or not running for the board being the individuals who are going through the ballot procedure, opening and counting of the ballot.
James, I hope that answers your question. Brenda has a question as well. Is the association required to provide an owner with the recording of a past board meeting when requested?
So that's an association official records question. The statute, and depends on condo versus HOA. On the condo side, it specifically states the word documents. So a video recording is not a document. Depending on how technical you want to get, a video recording is a bunch of zeros and a bunch of ones, and those are stored somewhere, even if they're in the cloud. They are zeros and ones, so you can make an argument that they're documents. On the HOA side, it talks about documents and other things that are in connection with the operation of the association, and so that has that catch-all language that the Condo Act does not have. So it's arguable on the HOA side that the recorded board meeting is available. On the condo side, you can make the argument that it's not, but it's one of those things that why would you try and hold it back from that particular owner? It's maybe a difficulty of delivering it to the owner as far as the product via email, maybe a file that's too large, but it'd be kind of up to the association on how they want to, whether they wanted to make it more difficult for that owner or less difficult for that owner.
Excellent. We're coming up on about 10 minutes or so left in the webinar, so let me jump into a few more questions that have come our way. In regards to COVID, a lot of associations and board members are concerned that there may be potential lawsuits that come down the pipeline for people that get sick. In your experience, is there specific insurance coverages that you could speak to for any lawsuits that maybe get applied against not only the association, but the board of directors if an owner does get sick with COVID?
So we've been having some active conversations with experienced insurance brokers, and carriers will, of course, do their carrier thing and deny claims. So the association, owner gets sick, owner decides to sue, they're going to sue everybody and their mother because that's what happens. And they sue the association because they were at the pool once and they got COVID. And maybe it was the pool, maybe it wasn't, but they might have been walking through the hall, they might have been at a Super Bowl party, who knows? But the association's carrier will most likely rely on exclusions for mold, bacteria, biohazard, pollution, and communicable diseases to try and deny the coverage. And the general liability policy is not health insurance, and COVID is a public health crisis. So these are the things we anticipate the insurers trying to get off the hook of giving the association coverage. So it's too soon to know. We haven't seen the lawsuits get filed yet, and coverage claims being denied by the insurers. But we have to assume that the insurers will, the carriers will fight it tooth and nail in order to avoid being on the hook for anything. So we do recommend that the association just assume that they don't have coverage. You can always have this conversation, of course, and we do recommend you having this conversation with the association's insurance broker to review the policies to see what exclusions you do have. There is apparently a new insurance product that's available that will cover some attorney's fees and costs, but it doesn't cover most of the attorney's fees and costs, and it doesn't cover expert fees or other costs that are the bulk of medical claims like this. So it's not that it's that expensive of a coverage, so it's something you guys could look into, but don't expect it to be a full bore coverage. You don't have a problem if somebody sues you for COVID.
Avi, in your opinion, does an association assume liability by having COVID protocols in place?
Yes. Once the association takes on an extra step, then they are taking on a duty, just like anything else. And the association has a duty to warn, a duty to do certain inherent things. But if you open up the pool and you say, we're going to do these 7 things to make the pool as COVID-free as possible, these are going to be our protocols that we're going to follow, and you don't do those, then you're opening yourself up to liability of you're creating your own bar, your own metric, and you're then not meeting that bar. So if you open up the pool and you have the chairs separated by 6 feet and you have the hand sanitizer stations, aside from obviously posting the correct notices as an example that was shown before, but make sure a log is kept of every time someone goes to clean it. Make sure, you don't need necessarily photographic evidence, but somebody's from the association, whether it's the property management company or if you're self-managed, whoever's in charge of cleaning that is signing a log that's part of the association's official records, that if there is an event later on where there's a lawsuit or someone claims that you weren't doing this, that you can show, look, we have this log, this is where we keep it, this is, with the date and time that everything was signed. And that would be evidence supporting the association's claim that it did what it said it was sent out to do. Now, there's things that Disney World, I'll use that example again, is doing that an association shouldn't be expected to do, particularly if it's a 15-unit condominium that doesn't have any amenities and their assessments are, a couple $100 a month. Are they going to be expected to now spend $1,000 per owner per month or whatever the increased fee would be to implement some crazy Disney World level COVID measures? And the answer is no. The association just needs to act reasonably with what they're able to do. But once you commit to something, if you're going to commit to something, then you need to keep that. If you want to keep the pool closed, you might get a lot of owners that are really unhappy, but you can keep the pool closed.
Avi, I think we have time for one more question, and it's a good one. It's a question that's coming up quite a bit, as you I'm sure are aware. What is the update, if any, with the eviction and foreclosure moratorium?
Sure. So that's been pushed through. Biden pushed that through to extend it until March 31st. Our approach is twofold. Number one, we recommend the associations. Obviously, a lot of people were hit hard with their businesses or their jobs with COVID. So before you get us involved as the lawyer, where it's going to rack up attorney fees and costs and make it more difficult for that owner to dig themselves out of the hole, have a conversation with the owners, try and work with them, create payment plans, see if they can come to a point where they're going to be able to work themselves out of the debt that they've gotten themselves in, the delinquency with the association, without then taxing on the attorney's fees and costs. If you do need to push it to the attorney with regard to collections, we're filing our liens, we're sending our letters, and we're filing the foreclosures, which we're allowed to do. The issue is that the sheriffs are not issuing writs of possession. So we're basically there's going to be a lot of cases that are in line waiting for the sheriff to serve come whenever the moratorium is lifted. When it comes to evictions, a lot of our association clients have bad tenants. The owner can't evict them, the association can't evict them because of the moratorium, but we've still filed them and we're trying to push them through. Sometimes we found that when we file the eviction action, either the owner and the tenant work something out, like a cash for keys type scenario, or the tenant just says, look, I need 30 more days and then I'm going to move out and we'll be out of your hair. I don't want this eviction hanging over my head. Sorry, let's enter into an agreement. And we've entered into settlement agreements with the tenants to try and get them out peacefully, as opposed to kicking heels and dragging them out the door, because we physically just can't do that, at least for another 6 weeks.
Avi, as always, this has been very educational. I hope all of our attendees have enjoyed today's webinar. As I mentioned earlier, if you are a board member looking for alternative management services at a higher level of service, please do not hesitate in contacting AKAM. I am directly available to you for any answers to questions and support. From a legal perspective, Avi Tryson is available to you as well if you're considering a change with your legal counsel or looking for additional legal counsel depth. Once again, thank you all for attending our webinar today, and we look forward to seeing you at our future ones. Thank you again.
Thank you.